and start this conversation, because there are layers of this. But there are two things that stand out for us right now. And this is on these two. One, a ruling that has come out of the High Court under Justice Bahati Mwamuye, as well as the split that we are seeing amongst judges when they argue on the age of consent and the punishment. Justice Odunga previously made his thoughts very clear when he said, you know what, and I'm just, you'll use the legalese, but it was clear for what he said. He said, you know what, we shouldn't punish these children who have engaged in consensual sex under the age of adulthood like we would somebody who has defiled another child. Basically, this is what he said, bringing in the Romeo-Juliet clause. And so now we're at a place where everybody's saying, wait a minute, so what does that mean exactly? From a legal point of view, looking at the age of what Kenya constitutionally decides a child will be a child and not an adult, how do these make sense? Let's start with this age of consent thing before we come back to what consent actually means.
So generally, under our legal system, the age of consent is considered to be, you come to majority, the majority age of 18 years. Our constitution defines a child as anyone who is below the age of 18. Adults are above the age of 18. And the same position is stated in the Children's Act. Perhaps, so that is the position in the law. What the judges perhaps are trying to say is that if a child has made a mistake, has engaged in something which they were not considered to have the capacity to engage in, they should not be punished. I feel like that's basically judicial attempts to bring law reform, but it doesn't give the judges a leeway to go beyond or to engage in judicial overreach. And that's what brings me to the decision that we under discussion today. The decision of Bahati Mwamuye, that it was just passed yesterday.
Yes.
In that particular case, it's good, perhaps, would you like me to give a context, perhaps, to enable us?
That would be great. Give a context, because then we can come back.
It's very important.
Yeah, it's very important to lay the ground for this. This is where this is all coming from.
Yes.
And then we can come back to your proclamation of judicial overreach, because that's already interesting.
So this decision is High Court petition number 400, E490 of 2025. I have the full judgment. I'll be able to share with you at the end of the program. It's good to also have it and go through it. That petition was brought by, there were 4 petitioners. So the first 3 petitioners were minors. The first and second petitioner are they are males or they are male children who were arrested and charged with engaging in sexual acts with fellow minors. So they were also they was at the time they were 17 years old, and the girls were 16 years old. Eventually, so this found its way to the Constitutional Court to determine the constitutionality of the charges, because the argument they were making is that these were consensual relationships. They were supported by there's a not-for-profit organization called NAYA. That's basically that promotes adolescent and youth interests in Kenya. And there were other parties that came in as interested parties. But the case before the court was basically seeking interpretation of Section 8 of the Sexual Offences Act. Section 8 deals with sex with a minor. Okay. Then Section 9, there's Section 9, rather Section 10, which would deal with... so there's Section 8 on sex with minors. Section 10, which would deal with what to call indecent acts with a minor. And there was a connection between these sections with Section 43(4)(f), which basically presumes that children do not have the capacity to make decisions touching on these particular issues or making decisions on sexual contact. So the argument was that it was consensual and not coercive. So they were seeking the court to get an interpretation or a declaration that if it is not coercive, it's not exploitative, then they cannot be charged with an offense. In the end, the outcome of the case was the court seemed to agree with them in the sense that the court made a decision finding those sections to be directing the various agencies, including the Director of Public Prosecutions, the investigative agencies, to align their policies to distinguish between those two sets of offenders. So if an offender is one who is seen as one who was engaged in a non-coercive, non-exploitative relationship, vis-a-vis the ones who are engaged in a coercive conduct. So that's the kind of distinction they were trying to draw.
Just do English for us.
Yes.
When you say non-coercive, that means I like you, you like me, we move. Right?
Yeah, that's what
coercive is you take it by force,
yes,
and you may even defile or hurt
yes,
at the time.
Yes,
right? That's
yes,
the two we're talking
yes,
about.
Yes.
Okay. So determination for a non-coercive relationship, how do you determine that this one is non-coercive, that these two have agreed?
Exactly. So that's why that's the problem exactly that is created by this judgment, because they do not tell us how to determine those kind of situations. That's the danger in the decision. The other danger in this decision is that it just talks of adolescents very generally. Of course, from general grammar, we consider that an adolescent, in some cases, like the World Health Organization defines them as one who is between the age of 10 and 19. But I think in Kenya, we generally take them to be people between the age of 10 and 17. So you can see they are saying that it has to be minors who are close in age in a relationship, a consensual relationship. So there's a danger there, because if I'm 10 and 11, it's okay. If I'm 11 and 12, it's supposed to be okay. It's a very dangerous.
But the only lines we are playing within this, the lines we're playing within here is for the purposes of determination of criminality.
Yes.
We are saying that if you are looking to charge somebody for a particular crime, had they engaged in sexual activity when one was 10, hey, God forbid, when one was 10 and 12 or 12 and 13, if they had agreed that they like each other and everything is okay, then we cannot charge them. But if a 14-year-old had taken it by force from a 12-year-old, then on that we can charge. That's essentially what this judgment is saying.
That's what it's saying. And
how do you determine that a 14-year-old took it from a 12-year-old by force, or that a 12-year-old gave it up to a 15-year-old without any problem? You were not there in the room, and we already know that the law is unable to interpret situations for which it was not present.
Yeah, that's really the danger that this decision has created. That it has left it at large. Who is to determine that? Because if you have a child and they face a situation whereby, let's call this other person a friend who is there facing a criminal sanction, they might feel the pressure to simply say it was consensual, even if it was not. So that's the difficulty it's creating, and I think it's very dangerous. The court, what I think the court should have done, the court should have called for legal reform on this subject. And there's many other subjects in the criminal justice system that require reform, not just the issues touching on children, but even generally, what are the sanctions available for different types of crimes? And the original sin in this case, I can tell you the original sin is what you call the case of Francis Muruatetu case. And that I'll trace the original sin to the Supreme Court. So the Supreme Court was faced with an opportunity to give an advisory opinion on whether the death sentence, as prescribed in the Penal Code, is unconstitutional. And the arguments went on and on about this is a violation of the dignity of the accused person, of the person who is facing this mandatory death sentence. And we went on to this discussion and forgot about what was the violation, because someone is facing this sanction for a violation that they engaged in. And that was the original sin. So what happened thereafter? Once the court made that declaration, then the courts became confused. We have courts claiming that a life sentence, because now they were given the option of a life sentence. Some courts think that a life sentence is 15 years. Others think it's 30 years. And that is not proper. In a criminal justice system, we need certainty. Criminal law has to be certain. You engaged in a certain conduct, this is the punishment. It must not be left to conjecture and manipulation and interpretation and judicial craft. So the original sin is in the Muruatetu case. It is the Supreme Court which caused all these problems, and now it is cascading down the hierarchy, the hierarchy of the court system.